Okay, I think we'll make a start. Just a couple of housekeeping matters. If you could keep your cameras off and your mics on mute, thank you. Today we'll be keeping an eye on the chat, so feel free to ask questions as we go, and we'll also be taking questions at the end of the session. You'll all receive a recording of the session post-event as well. So before we kick off, I'd like to acknowledge that I'm hosting this event from the lands of the Gadigal people of the Eora Nation. I also acknowledge the traditional custodians of the various lands on which you work today and the Aboriginal and Torres Strait Islander people participating in the event. My name's Erica Taylor and I'm the Director of Learning and Development here at ExpertsDirect. At ExpertsDirect, we source expert witnesses for litigation. We've worked on many complex matters that involve issues that are too complex to be resolved by a court alone. And expert evidence is oftentimes necessary to understand the complex issues in a litigated case. To properly understand these issues and address them, it's important to have the correct expert on the case. And to get the correct expert, the briefing and retaining the expert is of great importance. I'm currently spearheading the learning and development activities here at ExpertsDirect. And we also have a team of people that manage our panel of over 6,000 experts. We have a research team who source experts for our clients, a case management team who act as a liaison to ensure the smooth running of the engagement of an expert, and a quality assurance team who assists in the proofing of reports. It's my great pleasure today to host this event, Employers' Liability in a Post-COVID World. And our speakers today, sorry, I'm just having a bit of a technological issue with my slides. Our speakers today are Alicia Mataere. Alicia is a workplace relations partner at Holman Webb and has 15 years experience in employment and workplace law. Alicia has advised and developed strategies for clients across various industries, including government and private sectors, publicly listed companies, affiliated health organisations, religious and not-for-profit organisations. Also joining us is Andrew Clark. Andrew is a senior claims adjuster with Berkley Insurance Australia. He's a senior insurance professional responsible for a diverse portfolio of claims with a particular focus on professional indemnity, directors and officers, and employment practices liability. Andrew has been recognised in Insurance Business Magazine's 2019 Young Guns Award and has significant experience managing clients and employment-related disputes. And we're also joined today by Scott Fanker, Director of Workplace Investigations and Review at Centium. Scott is a workplace review and investigations consultant and has a background of working in clinical, academic and senior management, and also leadership positions in public sector mental health services. More recently, Scott worked in the New South Wales Ministry of Health in roles where he assessed, managed and investigated complex and sensitive complaints and misconduct matters across the health system. His expert witness experience extends to numerous matters involving employee risk assessment and mitigation. So our topics of discussion today are around general trends in the employment space with regard to employers' liability in a post-COVID world, how unfair dismissal and general protection claims differ, addressing workplace complaints and the impact of COVID on managing workplace investigations, and how the Fair Work Commission and Federal Court are approaching claims around vaccine and mask mandates. So as I mentioned at the beginning of the session, we're happy to take questions through the chat box. Just make sure that your chat is addressed to everyone in the blue box in the chat, and I'll certainly pass those questions along. And we'll also open up the session to all attendees if you have any questions at the end. So Alicia, I might start with you. What were the general trends that employers needed to deal with as part of the pandemic?
I think the major one was overnight entire workforces, particularly professional services, were sent home to work. That created a massive, not only a massive logistical issue, if you think in terms of IT, and dealing with that, having people being able to physically work from home, but also created a number of other risks in terms of safety. So the Model Work Health and Safety Act, which applies across the country, except for WA and Victoria, it's pretty much based on Victoria, so it doesn't really count, but across the country, if a workplace is defined as anywhere where work is performed, so overnight organisations had to deal with the fact that an employee's home became their workplace. So it wasn't coincidence that you couldn't get a office chair, a desk, a monitor, or anything to do with work during the pandemic, couldn't get it for love nor money. That was no coincidence. It was employers and businesses trying to deal with and cope with complying with a public health order that said employees needed to work from home where reasonably practicable. And, also, if you think about it at the beginning, we didn't really know a lot about transmission or any of those things. So we're just kind of trying to guide it as best we could. Now that shifting people home also led to another major trend, which was, everyone probably saw an influx of policies. So you had working from home policies, you had working from home checklists. A lot of businesses needed to update policies in terms of confidentiality, security. Us ourselves were joking about just previously the faux pas that happen when you work from home and have children running through the background, or cat faces on screen. All those things were things that businesses and trends are now, and now it really is a trend in terms of working from home. But I think that was probably the biggest one. The other one we saw was, particularly in the employment sphere, massive changes to modern awards. So I think overnight, or at least within a week, we saw the Fair Work Commission amend over 120 awards to provide for things like unpaid pandemic leave, changing the span of hours, because they were recognising that people are now working from home with their entire family and saying you're going to work from 9 till 5, or your span of hours is from 8 till 6, just wasn't going to work. And potential consequences being work outside of ordinary hours, underpayment issues, all of those things needed to be dealt with. They also dealt really quickly in terms of amending the modern awards to deal with leave without pay. Sorry, not leave without pay, annual leave at half pay. Because technically you couldn't take annual leave at half pay. It was you're on annual leave for half of it and we'll put you down as leave without pay for the other half. But those changes to the modern awards changed that. I think probably the other, I don't know if it's a trend, but at least some of the risks that came out of it was a change to our Workers' Comp Act, which I think ties into that little quote that you had, or was in the invitation, and that was, and it's still in the Act today. The Workers' Comp Act was amended to specify a number of industries, which is surprising or unsurprising. The normal unsurprising ones are health, public emergency services, hospitality, to say if you contract COVID and you work in one of those industries, it's presumed that you contracted COVID at work, and on that basis you can eligible to make a workers' compensation claim. But it also picked up things like retail. So if you think of anyone working in shops even today, there's still that presumption under the Workers' Comp Act that if they contract COVID, it's presumed that they got it at work. So I think they're probably the key trends that we saw, and we're continuing to see.
Yes, and that quote, just for the attendees reference again, was that according to SafeWork Australia, in 2020 there were over 1,222 COVID-19 workers' compensation or related workers' compensation claims. And I think the points you make as to people finding themselves working from home and then having their employers flood them with policies, and also the amendments to the awards. I'm interested to know, what did you observe in terms of your clients dealing with that? Because I imagine it would have been quite reactive, probably something that people always thought was a good to have in the back of their mind, but then all of a sudden it came to fruition overnight.
Yeah, absolutely. And I think that's where kind of all the discrimination issues come in, because previously these rights to be able to work part-time were often linked to a capacity to work from home, and the ability to deny that request, at least under the Fair Work Act, has to be based on business reasons. So previously businesses would say, we can't sustain it because we can't support working from home on a permanent basis. That argument has pretty much gone out the window now. You now need to disprove as to why that may be the case. That's probably the biggest change that we saw in terms of businesses being able to do it. I think the buzzword was agile. So overnight businesses needed to be able to not only support people to work from home, but to continue to run their business whilst working from home. So how do you interact with clients? How can you meet clients? What happens if you've got people traveling? How does that even happen? Even if you think about, most of the people on this call, how do you get to court? So it's kind of, if you told me when I started out that you could do court over the phone, I probably would have, laughed, been like, that's never going to happen. They're never going to do that. But even today, there's still, at least in the federal court, there's an assumption that it's online unless we tell you otherwise. So we're going to assume that you are not coming to court unless we tell you to come. So there've been, I think, massive mindset shifts.
Yes, agile and pivot, I think, was the other term that was frequently used as well.
Some people may be twitching, so I apologise.
And Andrew, I guess just looking at these issues in the context of your role and what you do, and Alicia, again, you might have observed trends in relation to patterns in unfair dismissal claims, etc. But Andrew, can you take us through the differences in general protection claims and unfair dismissal claims?
Absolutely. So in a nutshell, an unfair dismissal claim is essentially an allegation that the dismissal of an employee was harsh, unjust, or unfair. There are two components to these claims. The first being that there needs to be a valid reason for the dismissal. You can't just be fired for dropping a pen as you're walking through the office. The second component of that is procedural fairness, and that needs to be demonstrated to the employee. So the employee needs to be informed of the reasons for dismissal and allowed an opportunity to respond. So once that response is received, if it's deemed unsatisfactory, the employee needs to be given notice that termination is being considered, and again, given an opportunity to respond. Finally, if this is unsatisfactory, then the employee, the reasoning given for the termination needs to be clear and contained within the dismissal itself. Because there are two components, these are separate. If the respondent falls down on one of them, then the claim will be made out. So you might have a valid reason, but if you as the employer didn't demonstrate procedural fairness, chances are you're still going to fall down at that point. General protections claims, on the other hand, concern an allegation of adverse action taken against the employee. And this adverse action could be a number of things, from an employee exercising or proposing to exercise a workplace right, or that it involved aspects of discrimination, things along those lines. Essentially, any protected reason could be considered adverse action. And where these sort of differentiate themselves is general protections claims carry a reverse onus of proof. So the onus is on the employer to establish that an unlawful reason didn't factor into their decision to terminate the employee's employment. So that's where that difference is there, but differences also arise in compensation and what awards can be made out if the claim succeeds. Unfair dismissal claims are typically capped at 26 weeks compensation that is equivalent to 26 weeks pay, but reinstatement can also be awarded, though that is quite rare. I think over the 2020-21 period, the FWC, the Fair Work Commission, saw about 10,500 claims, of which only about 90 contained some element of reinstatement. So going by those numbers alone over a 1 year period, it's obviously pretty slim. General protections claims also have no cap on settlement like their unfair dismissal counterparts. So there's no 26 weeks cap. You it is uncapped, as I say. And these claims can also involve penalties awarded against the corporate entity and any individual named in the complaint.
And so when we first, COVID first came upon us, obviously governments were mandating requirements around masks, vaccines, etc. And then as we've sort of gone through the last 2 years, we've seen a number of those government mandates having been relaxed, but some employers choosing to still have their own mandates in that regard. How has the Fair Work Commission and the Federal Court approached mask and vaccination mandates?
Alicia, or
well, Andrew, perhaps you. I know that
Sure.
In terms of mask mandates, perhaps you could give us a few comments on that.
Sure. There's been some guidance from the courts in I think the last year or this year for the most part. There's the case of was it Mount Arthur or Mount Parker? Mount Arthur. It was Mount Arthur v. CFMEU, and that case, in a nutshell, came down to what is fair and reasonable in the workplace. Is it fair? Is it reasonable to dictate vaccinations, to dictate masks? There was a case involving a aged care facility and a caterer. So this aged care facility was being audited, and staff were told that morning that particular focus would be placed on PPE, personal protection equipment, and wearing it properly. At that time, none of the staff were told about the consequences of not wearing your PPE properly, not wearing your mask properly. So we have a caterer in the aged care facility. She's walking around doing her job. The auditors are there and they observe her wearing her mask below her nose. She was confronted almost immediately and said, wear your mask properly. She was told she'd pulled it down to speak to a resident that was of ill hearing. Manager didn't take that in stride, and she was summarily dismissed for not wearing a mask properly. The FWC said, well, no, that's not good enough. There was no evidence that the applicant's offence caused any serious or imminent harm to the residents or anybody else. So because of that, summary dismissal wasn't warranted. The absence of a warning rendered the decision harsh, and compensation equivalent to about 5 weeks' pay was awarded. So I think really it's a case of let's take a common sense approach to these sorts of things, which I know common sense is a term that's thrown around, has become almost cliche, but what common sense is sometimes lost. And I mean, really, in a case of an employee just happening to have the mask below her nose on one occasion, I think the commission just said, look, that's not good enough, guys. It's a bit harsh, a bit heavy-handed, and so that claim was made out for the applicant.
Yes, and it's very interesting too. I think that point about obviously masks were mandated for a very good reason, but there was a large number of the population who may be hard of hearing who were affected by the mask wearing. My sister is hearing impaired, and I know that she had terrible difficulties because she relies on lip reading. And it's comforting to know that the commission was reasonable and did appreciate that, okay, there may be circumstances where it's appropriate for someone to pull down their mask to be able to communicate, and wasn't I guess as militant as the employer was in that circumstance, saying, well, you're dismissed for not wearing your mask properly.
I think it also comes down to whether or not the wearing of masks is mandated by the government or a health organisation or authority, or if it is a employer imposed mandate absent any sort of government directives. Western Australia, for instance, had a directive to wear masks in the workplace. We managed to claim over there where an employee was dismissed for failing to comply with the government mandate. And I think that's a bit of a different scenario. In that case, if somebody is not complying with the mandate, it's a government directive. The employer's hand is sort of forced, I can say. might be a bit different where there is no government directive to that effect. And I think that's where the common sense comes into play, and being a bit fair and reasonable towards these things.
And Alicia, in relation to vaccine mandates, what has been the judicial approach to those over the since the pandemic began, and now that we're sort of post-COVID, so to speak?
Yeah. Well, I mean, the challenges to the government mandates have essentially been given short shrift by the court, and I think it was just last month the High Court denied the request for special leave. So in terms of challenging the mandate, that's not going anywhere. It's they haven't been successful on any attempt to do that. So then in terms of, I guess, managing it in the workplace, the Commission, I think there's most of the cases that we've seen before the Commission have involved, I think it's probably time-wise, like Andrew was talking about, government mandates. And there's been a number of them. And from memory, there's only 2 cases that involved government mandates where the employee has been successful. But the only reason they were successful, similar to what Andrew was saying, is because the employer in both instances didn't give the employee enough time to comply. So I think one involved a teacher in the Northern Territory who literally she had a week to comply, and she had written to them and said, look, I need to actually make an appointment with a cardiologist, and until that happens, I'll take leave. I know I need to take some leave without pay, but I just need to do this because I think a relative had a adverse reaction to actually having one of the vaccines. And oddly, the government employer turned around and said, no, that's not good enough, and sacked her. So that was one instance. And I think the second one, it was an employee in Victoria. They weren't a government employee, but Victoria had much more stricter vaccine mandates. And it said from a certain date, I think it was like February, all employees needed to be, in specific industries, needed to be vaccinated. This employee was in that industry, but he already raised an objection to it, I think in like December or something. And so the employer then sacked him. And they're like, well, you jumped the gun because your mandate doesn't take effect until February, so you should have waited until February. But they couldn't reinstate him in that case, even though he wanted to be reinstated because he wasn't vaccinated. So I think the Commission applying that common sense approach of, even if I do that, this guy's just going to come back. But I think outside of the vaccine mandates, and it's probably, I guess, that second kind of wave of trends that we saw clients dealing with was whether or not employers could mandate vaccines. And it was probably the biggest issue in the employment space once vaccines became available, even though they were scarce at the beginning. And that issue around whether or not, or the court's approach to considering the few cases that they have, has really been about, is it a reasonable and lawful direction that the employer is giving in terms of requiring employees to be vaccinated? So that's where we spoke about that primary safety obligation about requiring people to work from home. It was a similar situation in bringing people back into the office. So your primary obligation is to take all reasonable practical steps to ensure health and safety in the workplace. And employers needed to consider, is this high level order control of vaccine required of all employees? And if it's required of all employees, is it for clients, all of those questions. So risk assessments to enable businesses really to determine that. Is a question. So in terms of the court's approach, that's the first thing they're going to look at. And then assuming that's the case, they'll then look at, well, is there any medical reason as to why the employee can't? And if there is, what are the other ways where the discrimination aspect comes in? What are the other reasonably practical steps that an employer might take to be able to manage it? Is that allowing them to work from home the whole time? Requiring them to do rapid antigen tests on the rare occasions they need to come in? Is it saying you must wear a face mask whilst you're in the office, your face shield, giving them like all kinds of different options need to be considered to be able to meet that kind of second high bar of, is it a reasonable and lawful direction? And then I guess depending on which path the employee takes, unfair dismissal is the process thing that Andrew was talking about, but you first need to establish that you've got a valid reason, and that's all based upon, is it a reasonable and lawful direction that you require people to be vaccinated? So yeah, I think the court's approach has been quite sensible. Even when you look at the cases that look at the mandate, they're in kind of a polite way saying, you've asked the wrong question. And in terms of challenging this administrative process, we're not going to do that. So, you know, unsurprising that the special leave application was denied.
Was denied, yes. Well, it certainly sounds like over the past couple of years, you both would have been kept incredibly busy with all of these new and unique issues that you know had not been seen before. I know that prior to COVID, there were commission decisions regarding people working in aged care getting the flu vaccination. But obviously that was quite a more nuanced sort of consideration, whereas with COVID being so widespread, so contagious, you know, it's just been interesting, and I'm sure has given rise to substantially more work for you. So we sort of talk now about coming out of COVID or being at the end of COVID or existing in a COVID normal. Alicia, what do you see as the next challenge for businesses in continuing to manage the pandemic and the ongoing effects of it?
Yeah, I think we've seen kind of the biggest struggle, I think, for businesses has been getting people back into the office, bringing people back, whether that be hybrid, the replacement for the word agile, if it's bringing people back into a hybrid workplace, or even just getting people back initially seems to have been a bit of an issue, but it's similar to the reverse of sending them home, in that as long as you have comply with your safety obligations. So in terms of the direction, obviously any employee can give a direction, it's whether or not it's reasonable and lawful. And that question of whether or not the direction that someone returned to the office is reasonable and lawful is really based upon what procedures does that employee or that business have in place to comply with their ultimate safety obligations. So what is a policy around vaccine in the office? Are there procedures in terms of everyone who does come in warranting that if there is a vaccine policy, that they are vaccinated and boosted and comply with that? Things that we've seen is that nobody in your household has flu-like symptoms, which I think is quite an important one. Think about hand sanitizer, I think it's on the screen at the moment, hand sanitizer, tissues, all that kind of hygiene stuff. Can you ventilate it more? Can you spread people out? All of those things still need to be considered, because I think probably one of the biggest issues moving forward, I think, is remembering that it's still an issue. We've become quite complacent. And Andrew and I were talking, saying the numbers in terms of infections and deaths are higher in 2022 than they were at the beginning, not just because of obvious reasons in terms of opening up and stuff, but I think that in terms of a business or employer managing it, that puts a much greater obligation in terms of managing it, because the risk is in some respects higher than it was previously, because it is, it is amongst the community even more and more. So I think, the other big trend would be business, which leads into business continuity. Managing a workforce, you don't want entire teams out. We've had clients who've had proposed to have sales conferences where they're going to bring their entire sales force, all 300 of them, and show them in a room or a hotel for 3 days whilst they invigorate them all to go and sell. And we're trying to explain to them maybe that's not, maybe you need to put in some additional structures, like have people, especially if you're flying people in, have rapid antigen testing multiple times. Don't ask people to share rooms. If you think about it, your entire sales workforce, or even if a quarter of them were taken out, that's a problem in terms of business continuity. So regardless of what it is, I think that business continuity piece has been missing from a lot of businesses' COVID safety plans. And it's one that, in terms of profitability and moving forward is, I think, key to them being able to sustain moving forward, because we're not really out of it. We're not out of the woods yet. We're still pandemic, we're not endemic yet. So I think
yes,
they'd be my kind of three things, is remembering it's still an issue, business continuity, and having procedures in place to bring people back, and it makes them feel comfortable as well. Being comfortable with it.
Absolutely, yes. And I think that business continuity point is a really important one, because the effects of, as you say, having your workforce fly in for a conference, it's so much more widespread, not only for that particular business, but the businesses of the families of the people who may fall unwell. And Scott, you've sat there very patiently, and I can see you've got your hand up.
Well, I actually think that was an error, but I'll still take the opportunity to say something. And it's interesting. I've got an interest in this kind of question around the lawfulness of vaccine mandates as well. And just as an anecdote, of course, the sort of challenges to vaccine mandates are actually not that new. And there was a case that's still good law, I think, around an application to the US Supreme Court in 1904. And that was Jacobson in Massachusetts, and that was smallpox mandates. And in that instance, the US Supreme Court held the vaccine mandates for lawful. So 100 odd years later, we're probably still, dealing with very similar things to what the Supreme Court said in 1904.
That's very interesting. I wasn't aware, but obviously the issue of vaccine mandates, as you say, is not something that's just a contemporary issue. But considering all of this and given your background as a workplace investigator, obviously, as we've seen and we've heard from Alicia and Andrew, COVID has had substantial impacts on many aspects of business and employment. How has employee misconduct and in managing misconduct investigation practice been impacted by COVID?
Well, I think the first thing to say is that the pandemic hasn't gone away, and nor has misconduct. So we've seen no shortage of misconduct issues arising, even in circumstances where large parts of employers' workforces are working from home. And some of that misconduct took a similar set of stages and transitions to the actual pandemic. And in my former life in health, early on, there was a large number of matters that came up, a lot of which were dealt with informally rather than through investigations. But things like theft of hand sanitizer and masks and toilet paper from hospitals was a very alive issue in the early stage of the pandemic. And then what we saw in a health context, including sort of now in a private context, was that there was then things like time and attendance issues that were raised around people from working from home, some pretty creative deployment of technologies such as Microsoft Teams to indicate that people were available when potentially they weren't available. I have to say these are things that weren't that common because I think all of the sort of international evidence tends to be that people working from home have worked very successfully at home, and there's evidence of productivity increases, not decreases. And then to pick up on the point that's already been made, we've certainly seen some instances of employers taking the view that their employees are misconducting themselves by refusing to return to the office, and then that balancing act of what's reasonable when there's been 2.5 years of people working successfully in a hybrid model or a wholly work from home model. So certainly misconduct has not gone away, and it has been affected directly by the pandemic. I think employers can relate to each other inappropriately as effectively and potentially more efficiently online than they might do across workstations in an office. And so certainly we still see plenty of instances of people asserting unreasonable, or inappropriate relationships and communication with their colleagues. And a couple of things that I've noticed relates to resolution and early intervention, particularly around conflict. And I probably would say that my experience is that self-resolution, where an employee might approach someone and say, do you have a minute? I think we need to talk because we're not getting along. I think probably there is less of that in the virtual world than there might be in an office environment. And certainly I think we've had it reported to us that that managers may be reluctant to use virtual technologies to intervene early where employees aren't getting along, in favour of delaying those conversations for when people might be in an office. And there's some problems there around the longer you leave it, the more difficult it is to achieve a sort of resolution. The whole world's gone virtual. We're virtual today, and investigation practice has certainly been affected by that as well. And it's almost been law, L-O-R-E, that dealing with complaints is best done in person, face to face, and that's true of investigation practice for a whole range of reasons, including things like rapport or being able to read the responses that people give in an interview, better able to deal with distress, and sometimes symbolism about that if it's face to face, it gives an indication of the seriousness of the matter more so than talking electronically. But COVID then necessitated really a change in the way that investigations occurred, but I think it revealed that some of those truths that we'd inherited about investigation practice are probably not universally true, and that there are some advantages of investigating virtually. And some of those things that certainly I've experienced is interviewees taking the view that interviews are then held in a place that they feel more comfortable in. We've also had the experience that, given a choice, most people from our experience would elect electronic virtual interviews and face-to-face interviews. And people sometimes cite improved privacy associated with being interviewed online than the sort of walk of shame that sometimes happens in employment contexts, where someone is seen to go to that particular office where everyone goes when they're in trouble to meet with a bloke in a blue suit. And I think the technology is well suited to investigation practice. So things like pausing and taking a break if people need that during the interview, and audio recording. And my mediator colleagues talk a lot about the benefits of being able to put people into various rooms and then bring the parties back together in a way that they find very useful, and avoiding that sort of dance between the offices that mediation practices have sometimes had. And none of this is surprising. It stands to reason when everything up until including civil and criminal trials have been able to be held virtually. My tip is, in a post-COVID world, to go back to our theme, I think virtual investigation will very much remain a tool that is viable and frequently used in investigation practice.
And I think there are some parallels there in terms of the use of technology in investigative practice, as you've highlighted, but also and putting people maybe more at ease than they would be if they were in an in-person environment. And we're seeing the same thing, I think, in the courts, especially the criminal courts, for example, where you've got victims of crime who may have felt uneasy about having to appear in a courtroom, or someone in family law proceedings, for example, and the use of that technology, making it easier on the participants. Yep. But having a clinical background in mental health, what are some of the psychological issues arising from workplace investigations, and how do you think employers should go about managing those issues?
Well, I think that the point that's obvious to make, but work and mental health and wellbeing are often inextricably linked, and there's a substantial amount of international research now that says that work is health promoting, so people do better in their life when they work than if they don't work, and that there's also clear evidence that if work's not going well, that can have a deleterious effect on people's mental health and wellbeing, and cause significant psychological distress or manifest psychological disorders. In terms of investigations, my experience is that the legalistic and very procedural approach that you take to investigations can be, very, very confronting to people, even on top of what it is that, they're alleged to have done. And something that I find myself often reflecting on or talking to people about is it's not just respondents that find investigations quite distressing. It can be complainants and witnesses, and I'm not sure that that's always well understood and applied in practice. I'm not the best qualified member of the panel to talk about this, but it's someone who's a bit of a student of these things. Courts and tribunals, I think, are increasingly becoming alive to the concern about investigations and conduct processes generally running the risk of causing harm to participants. And I think it's Page is the old authority in New South Wales that said that the employer is not liable for psychiatric injury if in the context of a disciplinary matter. But there have been some instances in other jurisdictions where some challenges have been raised to that, and that courts certainly in Queensland have formed a different view about employers' liability in those situations. The other point I'd make is that we all bring certain vulnerabilities to the workplace, and they're not always known to an employer. And that's kind of relevant when you think about the lifetime risk that any of us might have a clinically significant psychological disorder, which sits around about 19-20% in the Australian community. So we're already dealing in a type of world that runs some risk of causing harm, and then we have employees who bring particular vulnerabilities. In terms of, what can you do? Some of the things that I am often talking to employers about is that when risk assessments are done and ways of dealing with mitigating risk are devised early in where there's a concern about misconduct, what I typically see is that risk assessment is directed to the organisation, and that might be anything to do with protecting further problems in the workplace. It could also be something a bit more ethereal about the reputation of the organisation. Risk assessments often properly directed to protecting a vulnerable complainant, and all of those things that sit around that. They're rarely directed towards looking at the impact for the potential employee and what the employer might do to lessen that impact. And sometimes the employer may do nothing more than just quite reflexively tell employees of the availability of the employee assistance program, and then do that in the same form of words in successive letters, but do little else. And certainly my experience, including as recently as this week with a matter that I'm running, a lot of employers that are subject to misconduct proceedings see that reflexive use of reference to the EAP is little more than just a kind of cynical tick box exercise in meeting some sort of liability related requirement. And I think the kind of more modern approach is, the better approach is that EAP is seen as one pathway that people can choose. But with large employers, there's often the ability for the employer to have some sort of point of contact back with the organisation, where the employee is able to have regular contact with the organisation, and that there's check-ins around that employee's well-being. In terms of the sort of strife that can come where these things are done not well, at the end I've got a bit of an anecdote which sort of ties up a few of the points around an instance where this was done very bad. And then I think the other thing that I see a lot is really the failure to provide the employee with enough information that puts them on notice about not just the misconduct, but all of the steps that will occur in terms of how that will be managed. Because obviously when people are forewarned and know where a matter's travelling, they're better able to manage that sort of from a psychological point of view.
And I think it's an interesting point that you make with regard to people who may have a pre-existing psychological condition, not only in the context of workplace investigations, but talking about having lived or living through the pandemic or being in the pandemic, how that may compound those pre-existing psychological conditions and create greater difficulties, not only for the employee, but then the employer if there's a subsequent issue and an investigation required. But Alicia, I wanted to ask you, in relation to Scott's point about people, now that we're all coming back to the office and trying to maintain some kind of hybrid working environment, or we see employers who really want their staff to come back into the office. What are you seeing in terms of what's considered reasonable? I mean, there would be a lot of people who, for their own reasons, just don't want to be catching public transport, don't want to be, out in crowded areas anyway, even though, we're told that we're kind of getting out of the pandemic. What sort of trends are you seeing in that regard with returning to the office?
We found it's a big issue for a lot of employers, and it depends on the business. So some businesses have rejigged their entire workforce, downsized, really embraced it, and just live off service offices. So it's not an issue. But for those who still want people in the office, and if they have good arguments in terms of it's about developing the other workers, the younger, more junior workers, them hearing and seeing and developing and seeing how things progress. I just think if people are bludging when they're at home. So, I always think they're bludging in the office as well. So that's a different issue as opposed to whether or not they should come back to the office. But again, and it's probably, one takeaway is safety is a trump card. So even the issues around they don't feel comfortable, catching public transport. I think Andrew was saying, masks from tomorrow, is it?
Yeah, tomorrow.
Yes.
The day runs out. Yeah.
Right. So all of those things are changing. Even if you catch a flight now, I think there's no obligation to wear a mask. So having people, and I guess where it comes into the return to the office, the policies that you put in place, even the vaccine policy, your COVID safety plan, you should have consulted about it. So if you've done all those things correctly and consulted, got feedback, the capacity for you to say it's a reasonable lawful direction, you're standing on pretty solid ground to say that, because you need to be able to meet that test as whether or not it's a reasonable lawful direction to be able to say you have to come back into the office. And I mean, the flip side to that is it's an employee's market at the moment. So businesses are also saying, how much do I want to try and recruit and find someone to replace this person in this current labour market? Or am I just going to put up with them coming in 2 or 3 days a week as long as the job's getting done? So it's probably going to change once the economic prospect changes. Once the job market changes, I think we're going to see businesses turn around.
I think that was. I think that's one of the key points as well to take away from Mataere and CFMEU. There was no mandate. There was no mandate for vaccinations at the time in New South Wales. So a requirement to be vaccinated when you're working underground in a mine and you can't socially distance 1.5 meters is not per se unreasonable. But the issue was the mine didn't consult the employees enough. You can't just hand down a mandate the next day, say, all right, guys, you got to be vaccinated now. It just doesn't work that way.
And in terms of that lack of consultation, though, and causing those difficulties, go from that very reactive position of employers in dealing with all of the different moving parts when COVID first started, and now as we've progressed. But I mean, I guess you'd probably see a lot of employers wanting a bit of a do-over in terms of formulating their policies and having that more in-depth consultation with their employees. So as you say, Alicia, then they're standing on solid ground in terms of saying, well, this is a reasonable requirement. Yeah.
I think consultation or just talking to employees. Sounds novel, but it's really important. Because they also have really good ideas as well, is the other thing. I think a lot is often lost in if you have great HR who's capable of talking to people, or even great managers. I think it's a real leadership quality to be able to talk to staff and say, hey, this is what we're thinking, this is where we're going. Obviously there's, sometimes there's business reasons to why you can't, but being able to have those conversations, I think, is a critical key to success.
Yes, and I think also the quality of empowering your staff and letting them know that they can give their input, no matter whether it be, or feedback, no matter whether it be positive or negative. That encouraging that transparent environment and hearing all views, not just sort of listening to people who are towing the line, so to speak, as to what they think they need to do. Sorry.
I was just going to say, and it can be difficult to manage that employer's expectation as well, because just because I'm asking you doesn't mean you're going to get your way. Like if you have consultation, is that it's just that.
Yes.
It's
sorry, Andrew. No.
It's getting these sort of procedural points nailed in the first place. I mean, the nature of insurance and litigation is that we step in when things have gone completely wrong. So by the time the claim gets my desk, the employee is gone, there's no take backs. And what you see again and again is employees not knowing the processes or not having the policies in place, not knowing that they have to talk to people. It's a novel thing, as Alicia said. Yeah, just getting these things down pat in the first place makes it a lot easier if it gets to the point where, you know, the insurer or the lawyer gets involved.
Yes, that risk management is so important. And Scott, just one last question for you. And I think you mentioned that you had an anecdote in this regard. Are there any particular issues that you see over and over again where, in the context of employee misconduct, that's been managed poorly or could have been managed differently?
Yeah, I mean, I think one of the pieces of advice I find myself giving to employers time and time again is just choose the right tool. And an investigation is not always the right tool. And there's a bit of a sort of myth that I run up against where it's seen that investigation can fix any manner of issue in the workplace. And I often talk employers out of investigating, because what they want to do is investigate performance or a grievance between people or a fairly sort of low level form of misconduct. And it raises a couple of issues, because usually at the end of the process, they still want to preserve an employment relationship with the person. But they then want to go off on this path that is sort of the nuclear reaction, rather than one that's a bit more nuanced and more likely to be effective, like bringing people together and talking, as we've been talking about. So I think that happens sometimes because investigation seems very tangible and emphatic taking on of an issue, but it can actually do more harm than good. And so there are plenty of times when it's exactly what you need to do, but often it's not the right approach. And I think that that's something that I see played out time and time again. The B word, which is bullying, seems to be one instance where that is particularly lends itself to employers believing they need to investigate because someone has raised bullying, rather than the employer maybe taking a breath and having a look at what actually is being raised here, and is an investigation what's needed, or is it a alternative dispute resolution type of intervention. So that's something that I think I see a lot. I see a lot of bad policy, and some of that bad policy can involve things like the policy sort of expressing that the employee can determine the process that's used to deal with an issue in the workplace, such as a complaint of bullying, rather than that the policy expresses that it's the employer who assesses and determines the right sort of pathway. Suspension from employment is something that is one of these days I'm going to get around to writing a paper on, because I spent a lot of time trying to undo sort of pretty capricious approaches to suspending employees, including in my former life in health, where you've got close enough to 200,000 people that work in health, and a lot of options to deal with risks that don't involve putting someone on the bench for weeks or months at a time. And then the case study, which is sort of ties in, I think, a lot of the things that I've talked about. It is a health matter, and it involves an instance where a manager approached the most senior person in a particular part of health, and in an exit interview. And on the way out, they said of their line manager that this person was a bully and raised a bunch of things about them. The employer assessed the material that was given to them and did a couple of things. They took the view that what had been raised was misconduct, and they suspended the employee, and the employee stayed suspended for many months. What took place over a number of months while the employee was suspended was that they had a very significant suicidal crisis and needed to be admitted to hospital for a period of time. And part of that was driven by hearing nothing from the employer for months and months and months about what was happening with them. And then in the lead up to their direct report resigning, they'd had a catastrophic event occur in their life, something that happens to few of us, but those of us that it would happen to are rarely unscathed by it. They were actually sexually assaulted, which was unknown to the employer, but it was certainly part of this sort of package of things that was going on. The employee had the presence of mind after they got well to consult a lawyer, a very well-known panel firm, experienced in dealing with employment law, and that activated a process to look at what had happened around the management of their employment. And that's when I was asked to come in and sort of have a look at the issues. Now, the employer made a decision to investigate, and they did that in circumstances where it wasn't reasonably open to form the view that the issues raised actually fell under any head of misconduct. The issues that were raised were interpersonal grievances and performance issues. The investigation method that was used was for an investigator to come in and interview all 18 people that reported to the manager, and do that in a very sort of exploratory way. It was to basically bring out your dead, tell us anything that you don't like about the manager. And then that was bundled together in this sort of pretty ham-fisted conclusion that he had misconducted himself. And what played out was a situation where Humpty Dumpty couldn't be put back on the wall. There just really was no way that you could restore the employment relationship. And the whole process took something like 9 months from beginning to end, and broke a person, and broke someone who most likely what they needed was a sit-down conversation with the most senior person in the organisation. They certainly didn't need a sort of torturous investigation process, and one that was based on going looking for evidence by talking to everyone rather than following evidence, reasonably in search of whether there's been misconduct. And the only way this could be resolved was that a settlement was reached with the employee, but it stayed with me for a number of years about just how harmful the process had been to this person. And as an I talked to a lot of people, about this incident's way of sort of trying to sort of teach some principles or impart some principles around use the right tool, treat people with respect, do it quickly, don't investigate what's not misconduct, and don't suspend people for indefinite periods who are, professionals who are used to working, and then this was a scientifically trained person who didn't do well sitting on the couch waiting for month after month. So somewhere in all of that is my kind of golden rules around investigation practice. Only investigate when you need to, do it as quickly as you can, communicate, be decent, avoid suspending people unless there really is no other way of managing risk.
No, that's very interesting, and I think we've highlighted today. I mean, managing people as an employer is challenging enough as it is, but then with the layering of the pandemic on top of that, it's it's become even more difficult, and we've seen that with Andrew and Alicia speaking about issues they're seeing in the insurance space and the employment law space, but also you, Scott, as a workplace investigator, and seeing those impacts. I'm mindful of the time, and I notice it's just after 2 o'clock. I just wanted to open the floor up to anyone in our audience who might have any questions. Feel free to pop them in the chat. I mean, I think that's been a really interesting and stimulating discussion, and valuable for people who work in multiple areas, whether they be employers themselves or work in the workplace investigation space and employment law, etc. So I haven't got any further questions, and I'm sure many of you now need to get to other commitments and meetings. So Andrew, Alicia, Scott, again, thank you so much for giving up your time so generously. Very appreciative. I'd also like to thank the team at Holman, Webb, and Bill Montgomery, who was a great assistance in facilitating this webinar, but unfortunately couldn't join today. So thank you, and thank you everyone for attending. We'll share the recording after the event with a short survey. So with that, I'll leave you and wish you all a good afternoon.
Thank you.
Thank you. Bye.